My name is Praise Sumanko, and together with Group 2, we're going to be presenting on data protection and interception of communications. So first we're going to go and head on and define what data actually is. According to the Cambridge Dictionary, data is defined as information in either facts or numbers that have been gathered in quantity and recorded for the purpose of reference or analysis. So after defining what data actually is, we go on and define what data protection is. The reasoning behind this term is established from the constitutional right for privacy, that including data privacy, which states that every person has the right to privacy, which includes the right to not have their home premises or property entered without the permission of the person, and also having their data communications privacy infringed. So data protection can simply be translated to saying that private information which cannot be shared and or accessed to other individuals or entities without the permission and consent of the person whose data is being infringed. So what data is protected under the Act? Number one, there is identifiable data. This involves any person, natural or juristic, as long as the person is living, is identifiable as a person. So Section 3 of the Data Protection Act specifies that a person can be identified either directly or indirectly, including with their physical, physiological, mental, economical, social, and cultural identity. It should be noted, however, that the Data Protection Act only focuses on the living person and not the deceased person. So then there's a question that arises that, does it mean that a human person in their humanity as well as their human rights falls away the second or the time the person is deceased and has passed on? The second type of data that is protected under the Data Protection Act is sensitive data. This includes the person's nationality, sexuality, membership in politics, religion, race, gender, etc. All of this information can be seen as sensitive data and is protected by the Act. We're going to move on to the other aspects that are protected with the Data Protection Act. This includes the non-sensitive data that requires person's consent, which is on Section 10, the sensitive information with regards to Section 11, and as well as genetic data, biometric data, health data with respect to Section 12 of the Act. So, protection of information versus access to information and expression to information have been seen to have a disparity between the two, and we're going to see if it is actually true. So, as we have mentioned before, Section 57 of the Constitution protects the data of the person as well as their privacy. Section 61 protects the right to freedom of a person, and Section 62 protects the person's access to information rights. These rights may look like they diverge, however, they do actually work hand in hand. So, Section 61, subsection 1, Section 61, subsection 3 states that a person can have their right to freedom as long as it does not infringe the person's right to privacy. This is also seen on Section 2, subsection 3, which states that every person has the right to correction of information or deletion of erroneous, untrue, or misleading information. As you can see, these sections, as they protect each other's individual sections of access to information or freedom, they do always have to protect the right to privacy so that it will not be infringed. All in all, there's a theme to strike out a balance between these rights and freedoms. So there's a case of Flitcroft versus MGN Ltd, where a Premier Football sought to prevent D's newspaper from disclosing or publishing information concerning his sexual relationships. The court held that there was a need to strike out a balance between the right to privacy for confidentiality purposes, as well as the right to freedom of expression and the right to access of information for transparency and accountability. Now we're going to go on to the data protection principles. The first principle is fair and lawful processing principle. This principle under the UK Data Protection Act stipulates that processing of personal data must be done in a fair, lawful, and transparent manner. This principle was previously incorporated in the Access to Information Protection Privacy Act, in short AIPA, on Section 30, subsection 2, which required a public body to inform a person to which they wish to collect information from, as well as the reasons and the authority to which they will be acting on. However, the fairness aspect was lacking in the AIPA, which is now being incorporated into the Data Protection Act on Section 8, which stipulates that the data controller should ensure that data is processed fairly and lawfully. Number 2, purpose specification principle. This principle, this guideline, is that data should be collected, stored, used for specified purposes and lawful purposes only. The only way data can be collected for reasons other than the specified reasons would be through legal and authorized consent. In the previous act, which was AIPA, it was on Section 29 and 36, and it is now incorporated in the DPA, which is the Data Protection Act, on Section 9 as well as on Section 13C. Then we are going to move on to how this principle works. The principle has 3 requirements of consent. The first requirement is that the consent must be explicit. This is not the same as when websites ask for users to accept information without further explanation. The second requirement is the consent must be specific and well informed. Therefore, the blanket consent would not meet the requirements outlined here. And the last requirement for the consent must be that the consent must be freely and voluntarily given. It should be noted that a person is entitled to revoke their consent to sensitive information as according to Section 11 of the Data Protection Act. The third one is adequacy and relevance of data principle. This principle is to ensure that information being processed must be limited in relation to the relevance and quantity of a person's information that will be processed. So this principle was stated out into the AIPA, and it is also in the DPA. This means that excessive collection of personal information will be irrelevant to the purpose that it would be taken for, is unlawful. This principle sparked debate in 2018 in Zimbabwe on whether the inclusion of voters' photographs on the voters' roll signify excessive information in 2018. The fourth principle is accuracy of data principle. Data must be accurate and not misleading. This principle denotes that data controllers must regularly update data that it may be accurate. This under the AIPA was on Section 31, and it stated that a public body must ensure steps to make sure that data is accurate, complete, thereby ensuring a positive obligation on the government department that collects data. The fifth principle is retention of data. The UK Data Protection Act stipulates that personal data must be kept for no longer than is necessary for the purpose it is collected. The principle is enshrined in the DPA Data Protection Act on Section 7, Section 7, subsection 1, paragraph C, which states that collecting of data should be kept for only necessary purposes only. The question arises here, however, that how long is a necessary period? So Murinda in his book gives an illustration of an health practitioner who keeps the information of a patient for long periods of time. This is a reasonable amount of time because they might need it for reference later on. So this was found in the AIPA Act on Section 34 and is now on the DPA as well. There's a leading case on this matter, the case of Pajakawambwa versus Portcullis, PVT, which says that the applicant's previous criminal conviction information was kept in a credit bureau's database and was supplied to financial institutions for assessing the credit worthiness of the applicant. The applicant wanted the retention of data to be removed, and the reason was that they could not access loans in the banks because of that information. The courts held that the retention of criminal record for a long period of time of indefinite time was reasonable because it was of a criminal offense. This is also recorded in the Ara versus Chief Constable South Yorkshire, where the DNA samples and fingerprints of a person who was convicted was their data being retained was lawful and was not contrary to Article 8 of the Human Rights Convention. The sixth principle is data rectification principle. This principle is in line with the constitutional right, Section 62, subsection 3, on access of information on the correction of deletion of inaccurate information. This principle therefore stipulates that persons are entitled to attain information held against them and to have that information rectified. In other words, to have that information corrected if it was inaccurate. This is under the DPA section 14D and E, with the corresponding duty on the data controllers to attain correct and accurate and complete information. Then our last principle, which is data security principle, which means that a personal data held by the data controllers should be held securely to avoid disclosure and unauthorized processing by third parties. Therefore, the principle calls for enactment measures to secure the data. Under the UK Data Protection Act, the personal data must be processed in a manner that includes taking appropriate security measures as regards to risks that arise from data processing any personal data. Under Zimbabwean law, this is captured under Section 18 of the Data Protection Act, which requires data controllers to take appropriate technical organizational measures that are necessary. So that is all we have on the data protection principles, and then my colleague Justin will continue with our presentation. Thank you.
Hello, my name is Justin. Yes, I'm going to talk about data protection laws. And before I get into the main issues, I want to have an highlight of why having data protection laws. And of course, data protection laws are principally designed to guarantee the rights of data subjects and imposing statutory obligations on data collectors in respect of personal information. So take a scenario where every individual in the data space had access to your personal information. Also take a scenario where state business is to be accessed by anyone who wishes to. Thus, data protection law seeks to achieve, amongst other things, the protection of human dignity, the protection of the right to privacy, and also with the main object of achieving economic development of any state. It is to be noted that data protection laws are not put in place only for electronic data, but also extend to manual filing systems like at workplaces, card index systems which stores information about individuals or employees. Of course, it is an undisputed fact that it is impossible to go about our lives and conduct business without leaving digital footprints. Such footprints require some sort of protection, hence data protection laws. Without such laws, there is great danger of personal sensitive information being abused. Take note of the continuing advancement of technology and also the need for international trade. This has brought about the issue of having data protection laws internationally. That is the issue of trans-border data flows. So I want to talk about what is trans-border data flows. Okay. I wanted to talk about the issue of trans-border data flows. I was saying due to the increase or the increased demand for trade internationally, there's some sort of transfer of information from one state to another. So there's need for the protection of data and also the need to formulate policies, laws to protect such trans-border data. As alluded earlier on, technology has made it possible for information to jump national boundaries at the click of a button, according to Lazarus Murinda. So trans-border data flow is the transfer of data across national borders by anyone of a variety of media. As alluded earlier on, there is need for data protection whenever you are transacting, whenever you are doing business internationally. So this has brought about the need to protect data from abuse or manipulation by other countries. So trans-border data flow is the transfer of data across national borders, and such data would normally be stored or reprocessed in a country other than the originating country. According to Ian Walden and Nigel Savage in their book, Information Technology and the Law, in the past decades, the development of more sophisticated telecommunication systems coupled with the growth in computing has resulted in a growing international trade, information, and associated services. Indeed, most aspects of our lives are now dependent on some degree on computer and telecommunication technology. Indeed, most aspects of our lives are now dependent in some degree on computer and telecommunication technology, ranging from news, education, manufacturing, to national defense and weather prediction. Such technology does not recognize natural state borders. Thus, the increasing ease with which information could be transmitted outside the national borders calls for the international harmonization of data protection. In this regard, the Data Protection Act of Zimbabwe deals with the issue of trans-border data flows. The Act prohibits the transfer of personal data on a third party who is in foreign country unless an adequate level of protection is ensured in the country of the recipient. I will talk about data protection laws in Zimbabwe. Of course, the relevant act which provides for data protection in Zimbabwe is the Data Protection Act of 2021. It is important to note that before this act came into place, there was IPA, which also contained the provisions of data protection in the form of regulating the collection, use, retention, as well as transfer of information. Privacy is also protected under the common law Actio Injuriam, which calls for the issue of payment of damages whenever data protection or data privacy has been infringed, the right to privacy has been infringed. We've got data protection under the constitutional framework. It has to be noted that there is some sort of inherent conflict between the right to privacy and also access to information. So the Constitution, of course, does not explicitly provide for the right to protection of personal information unless such information relates to privacy of the communications or person's health condition. Thus, the Constitution of Zimbabwe provides for a general right to privacy, embracing the right of every person not to have their home, property, premises entered without their permission, their person, home, premises, or property searched, as well as the privacy of their communications infringed. It has been asserted that Section 57 is not exhaustive in as far as a right to privacy is concerned. This entails that Section 57 is the bedrock of data protection, of course. And also Section 62 of the Constitution provides for data protection by giving a right of correction of information, deletion of untrue or misleading information. Thus, such provision in itself points out to data protection, which is more based on preventing data manipulation. Other acts of parliament. Besides the Data Protection Act, we have got the Freedom of Information Act, which gives a constitutional right of access to information and also embodies a number of provisions which seeks to protect personal information from abuse. We have also the Consumer Protection Act, which deals with the right to confidentiality of consumers as well as protection of their personal information during the conduct of business. We also have the Postal and the Telecommunications Act, which prohibits the unnecessary and unjustifiable disclosure of confidential information by inspectors or employees of portals in the course of their duties. We also have the Banking Act. Of course, to a lesser extent, it provides for protection of personal information to customers. However, it does not give specific obligations on banks to safeguard the privacy of personal information to its customers. We have to talk about the issue of common law and data protection. Of course, the right to privacy is recognized under common law. Thus, an infringement of one's personal information constitutes injuria capable of redress and under the law of delict. In the case of X versus Rhodes Printing and Publishing Company, the court held that the identity of children in a custody dispute should be protected from disclosure and manipulation. So in this regard, you realize that data protection law seeks to control the flow of information and also protect the privacy of individuals and avoid unjustifiable dissemination of personal information, while access to information rights seeks to achieve free flow of information across the communication divide. So there's need for harmonization of acts so that inherent conflict between these two rights has to be balanced. I thank you.
Good day, my name is Ngwane Kwashiwa and I'm going to be focusing on regional and international instruments on data protection laws. So I'm going to give an insight of some of the commendable regional and international instruments on data protection laws. First, I'm going to start with the European Union Data Protection Framework. So in 1995, the European Union Data Protection Directive was adopted. It aimed at harmonizing different national laws of member states, regulate processing, use, or exchange of personal data. It was also aimed at protecting privacy and safeguarding of personal data of the European Union citizens. The Privacy Directive was to provide a coordinated legal framework in the level of protection of rights and freedoms in relation to personal data in all member states. Article 32, Sub-Article 1 of the directive required member states to amend and introduce national legislation in compliance with the directive by 1998. So I'm going to move on to the main principles of data protection with regards to personal data in terms of the directive. Number one of the main principles was to ensure that personal data is processed lawfully. It is collected for specified, explicit, and legitimate purposes, that it must be adequate, it must be relevant and not excessive in relation for the purpose which it is collected or processed. It must be accurate. It was the duty of the member state to ensure that inaccurate data must be erased or rectified with immediate effect. Article 17 of the directive provides for a criteria for making data processing legitimate and circumstances under which personal data may be processed. So personal data may be processed when an ambiguous consent has been given by the data subject. 2, when processing is necessary to a contract which the data subject is part of, or in order to make prior steps before entering into a contract. Also for compliance with any legal obligation to which the controller may be subject, and also to protect vital interests of the data subject. Moving on, the transition of personal data to non-EU member countries was prohibited. It was only permitted when there is adequate level of protection. This is according to Article 25. This posed a problem when it comes to transmission of Article 25 of the directive provides that transfer to the third country, that is to say non-members of the EU, may take place only if adequate level of protection is ensured. So this posed a problem when it comes to trading operations with the US. Remember, the US is not an European member. So to address this gap and ensure that trading operations between the US and European countries continues, US entered into a safe harbor agreement with the European Union, and in this agreement the United States it undertook to meet the standards of the directive. So there was going to be transfer of personal data between the European Union and the US. Also, the European Union has been commended for being a comprehensive data protection framework with implications extending to other countries outside the European Union. I will move on to the US data protection law. So with the US data protection law, you'll find out that the legal framework is fragmented. There isn't any one legal instrument that actually deals with data protection in terms of personal data. So there are some of the prominent sectorial legislation in the US legal system, and this includes the Video Privacy Protection Act 1988. It regulates disclosure of specific video sales and rentals information to third parties. There's also the Driver Privacy Protection Act 1994. This prohibits Department of Motor Vehicles from disclosing information from driver's records. There's also the US Privacy Act of 1979. It provides legal safeguards on government's ability to collect, maintain, use, and disclose personal information. The judiciary of the United States, in the case of Warland versus Roe, pointed out that the US does not have an overall data protection legislation, as the area of law is regulated on the sectorial basis. Some of the sectors mentioned include that of the collection of taxes, distribution of welfare and social security benefits, and also the direction of the armed force. The United States legal framework on the protection of personal data has been criticized for the self-regulation approach without any underlying legal framework. For example, it leaves the use of privacy to business self-regulation. This shortcoming of the US laws on personal information actually will lead to a greater space for the exploitation of personal data. I will then move on to the South African data protection system. It has been commended for being a comprehensive data protection legal framework in line with international standards. The primary legislation in this regard is the POPIA, the Protection of Personal Information Act of 2013, that regulates the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, subject to justifiable limitations aimed at protecting other rights and important interests. The Act provides for a comprehensive definition of what personal information is, and this encompasses personal opinions, views, or preferences of a third party concerning the information of an individual. It further creates a subcategory of special personal information to which requirements for processing are attached, and this special personal information includes one's religious, philosophical beliefs, ethnic origin or trade union, political persuasion, health or sex life of the data subject. It also provides for circumstances under which personal information may be processed, and these include Section 4, Subsection 1 of the POIA Act sets out conditions for lawful processing of information, namely accountability processing, limitation, purpose specification, and information equality. The shortcomings of the provision are that the provisions of the Act have not been fully implemented since 2013. I'll then move on to look at the regional data protection framework in terms of personal data. So an attempt has been made at regional and continental level to come up with uniform data protection standards. Notable developments have been noted in the African continent, and these include the SADC Mod Law on Protection, which was implemented in 2011. So it was developed to guide member states in coming up with national data protection laws. It provides for the objective of data protection legislation, that is to combat violations of data likely to arise. It also distinguishes between sensitive and non-sensitive data and establishes the need to protect higher standards of protection on sensitive data. It also advocates for establishment of data protection authorities responsible for ensuring compliance with data protection laws. It deals with regulations and processing data. It also provides for rights of data subjects and obligations of the controllers. Therefore, there is the need for adequate legal safeguards of personal information, which is a mandate in terms of this SADC mod. I'll then move on to the African Union Convention on Cybersecurity and Personal Data Protection. This was adopted on the 27th of June 2014 by the 23rd Ordinary Session of the Assembly in Malabo, Equatorial Guinea. So this one was to harmonize legislation in the area of cybersecurity between the member states and establish mechanisms capable of combating violations of privacy necessitated by personal data collection, processing, transmission, storage, and use. Article 8 provides that it calls upon each and every member state to establish a framework aimed at strengthening fundamental human rights and public freedoms, with special mention to the protection of physical data and to punish any violation of privacy without prejudice to free flow of personal data. It also requires establishment of national personal data protection authorities. The Act further provides for a definition of personal data in Article 1, and this extends to cover sensitive data, that is data relating to things like sex life, race, and health issues. The definition is sufficiently adequate to cover any conceivable forms of personal information. The AU Convention contains principles governing the processing of data, and these include: number 1, the principle of purpose, relevance, and storage of processing personal data. Number 2, the principle of transparency of personal data. Number 3, the principle of transparency of personal data processing. Number 4, the confidentiality of security of personal data processing. The Act further provides for rights of data subjects and corresponding obligations of data controllers. These rights include the right to information, the right to access information pertaining to their personal data. The obligations of the data controllers include that of providing information when it is necessary, to ensure that processing shall be confidential, and also that data is not stored for more than necessary, and also that data can be utilized regardless of the technical device employed. So this convention is a key instrument in fostering protection of data of the member states. Also, Zimbabwe as a member state is bound to establish a legal framework consistent with these standards. So this marks the end of our presentation, right?
Good afternoon. My name is Sasha Mfundis, and I'm presenting on interception of communications in Zimbabwe. So, interception of communication, also known as communication surveillance, involves the monitoring, collection, interception, preservation, and retention of information that has been communicated, relayed, or generated over communication networks. The spread of new technologies and the improved capacity of government surveillance and spying software presents new threats to rights such as privacy and the freedom of expression and opinion. Although they are purportedly deployed for combating crime and terrorism, these software programs are commonly known for being used to clamp down on dissenting views by journalists, opposition political figures, and human rights defenders. So, I'm going to look at the relationship between the right to privacy and interception of communications. Privacy is defined by the Special Rapporteur on the Promotion and Protection of the Right to Freedom of Expression and Opinion as a presumption that an individual has an area of autonomous development, interaction, and liberty, a private sphere without interaction from others, free from state intervention and excessive intervention by uninvited individuals. The right to privacy is protected in Section 57 of the Constitution, which provides that every person has the right to privacy, which includes the right not to have their home, premises, or property entered without permission, and as well as having their home, premises, and property searched. This also extends to privacy of correspondence, which should not be violated. The right, however, is not an absolute right. The right is subject to limitations in Section 86 of the Constitution. The right is also enshrined in Article 12 of the Universal Declaration of Rights, Article 17 of the International Covenant on Civil and Political Rights, Article 14 of the International Covenant on the Protection of Migrant Workers and their Families, as well as Article 16 of the Convention of the Right of the Child. At international level, state surveillance is contrary to the dictates of international law. However, state surveillance is allowed in certain instances. It may be authorized where it is subscribed by the law, and it is carried out for a legitimate purpose. The Human Rights Committee, in its general comment number 34, stipulated that state parties must take into account the extent in which developments in information and communication technologies substantially changed communication practices. The report provides that states should only electronically intrude on a person's device as a last resort to prevent or investigate a specific act amounting to a serious threat to national security or specific crimes. I'm going to look at what are known as the Snowden revelations. So these were disclosures made by one Edward Joseph Snowden, who was an American former computer intelligence consultant who leaked highly classified information from the National Security Agents of America. So these revelations have fueled debates over mass surveillance and governance secrecy and have increased the need by states to balance between protecting national security and privacy of individual information. The disclosures were an awakening call to international policymakers that there is need to formulate laws that protect national databases, servers, and data more than ever. Moving on, I will look at the frameworks on interception of communications. We have international frameworks such as the Universal Declaration of Rights, which provides that no one shall be subjected to arbitrary interference with this privacy, family, or more correspondence in terms of Article 12. The International Covenant on Civil and Political Rights also guarantees the right to privacy in terms of Article 17. Article 17 provides for the direct protection against interference with correspondence, which must be interpreted as encompassing all forms of communication, both online and offline. However, it is imperative to note that the right to privacy is not regarded as an absolute right under this covenant. There are certain limitations that are imposed on this right, and these limitations must be legitimate, necessary, and proportionate to the interference sought. Then we have what are known as the necessary and proportional principles on communication surveillance. These a set of 13 principles that were adopted by the United Nations, which provide context of how mass surveillance should be carried out by states. The main purpose of the necessary and proportionate principles is to provide civil society groups, states, courts, and legislators and other regulatory bodies with a framework to evaluate whether current or proposed surveillance laws and practices around the world are compatible with human rights. The principles advise on the fact that communication surveillance must be prescribed and regulated by the law, be necessary and proportionate, and they must pursue a legitimate aim and must be subject to certain safeguards, including that powers are subject to a competent judicial authority and necessary transparency and public oversight measures. Principle 3 of the necessary and proportionate principle speaks to the need for there to be a legal reason why interception is conducted. States are prohibited from adopting and implementing measures that interfere with human rights in the absence of an existing publicly available legislative act which meets the standards of clarity and precision sufficient enough to ensure that principles that individuals have advance notice of and can foresee the application of the provisions of the act. There is also a principle of necessity which is provided for in Principle 3. This principle provides that surveillance laws, regulations, activities, and powers and authorities must be limited to those which are strictly and demonstrably necessary to achieve a legitimate purpose. Communication surveillance must be conducted only when it's a means of achieving a legitimate aim. The principle of proportionality entails that in order to meet the proportionality threshold, states are required to prove the existence of certain circumstances to a judicial authority prior to conducting such surveillance. This includes the high degree of a probability that a serious crime or threat to a legitimate aim has been carried out, and that other less invasive techniques have been exhausted or have proved to be futile, and the information required will only be accessed by the specific authority through interception. Then there is a principle of judicial authorization. Prior to carrying out a hacking measure, governments must make an application setting forth the necessity and proportionality of the proposed measure to an impartial and independent judicial authority, which shall determine whether to approve such interception and oversee its implementation. The principle of user notification provides that authorities are required to notify the person whose communication has been subjected to interference pursuant to an authorized hacking system. The affected software and hardware manufacturers and service providers must also be notified with regard to details on the method and extent and duration of the hacking measures, including specific configurations on the target. It is imperative to note that these principles, they are in themselves not binding, but rather they offer a series of principles that act as guidelines on how states must conduct surveillance or interference of communications. They form part of what is known as soft law, which adds flesh on the rights and principles that are contained in international instruments that are legally binding, such as the International Covenant on Civil and Political Rights and the Universal Declaration of Human Rights. At the regional level, we have the African Charter on the Rights and Welfare of the Child. Article 10 provides that no child shall be subject to arbitrary or unlawful privacy, interference with this privacy, or family, home, or correspondence. This charter creates binding obligations on Zimbabwe to ensure that the right to privacy is protected. Then we have the Declaration of Principles of Freedom of Expression and Access to Information in Africa. This again is a soft law corpus which seeks to add flesh on the hard law African human rights jurisprudence encompassed in the African Charter on Human and People's Rights. The declaration encompasses the principle of non-interference, the principle of privacy and protection of personal information, and the principles of on privacy and communication surveillance. I think.
Hi everyone, I'm Geraldine Gabalnocheka, and I'm going to be continuing our presentation from the Zimbabwean legislation, main focus being on the Interception Act. The Interception of Communications Act governs the exercise and practice of communication in Zimbabwe. The act is used to govern electronic and online communications for reasons such as the threat to national security and prevention of crimes, amongst other reasons. So we have lawful and unlawful interception, and in terms of lawful interception, a member of the public who seeks to gain a warrant to obtain permission to intercept another person's communication has to be an authorized person, and among those authorized persons include the Chief of Defense Intelligence, the Director General of the President's Department responsible for national security, the Commissioner of the Zimbabwe Republic Police, and the Commissioner General of the Zimbabwe Revenue Authority, or any other person who is an equivalent nominee to these persons are the only persons allowed to grant and apply for warrants. Warrants are submitted to the Minister of Transport and Communications and any other person whom the President may assign as the administrator of such warrants. Section 5, subsection 2 of the Act provides that application for warrants shall be made by an authorized person to the Minister and for the Minister to issue a warrant for the interception of communication. The position of our law is in respect of applications for warrants is quite different from that of the South African judiciary, where the applications are sent to the judges in the chamber. This means that our surveillance system lacks judicial or independent oversight to ensure that the minister does not abuse his powers to issue warrants. As Morinda in 2022 currently puts it, a possible repercussion created by this legal lacuna is that authorities may obtain warrants to intercept private communications through a process that is controlled by the members of the executive and not subject to independent scrutiny and oversight, whether it's judicial or by any other monitoring body or public. And then there are grounds for the issuance of a warrant. A warrant has to satisfy certain conditions for it to be granted. The minister is empowered in terms of the Act to issue a warrant, and there are reasonable grounds for the minister to believe that a serious offense by an organized criminal group has been or will be committed. The minister may also issue a warrant where it is necessary to gather information concerning an actual threat or to aid the national security, threats to any compelling national interest, or there is potential threat to public safety and national safety. The minister is the one with absolute discretion as to whether or not the grounds are reasonable for a warrant of interception to be granted. And the only threats that are to be measured against are if there's a threat to national security or public security. There is, however, a lacuna or a gap in this legislation in respect that the terms national security, public interest are not fully defined and they are subject to misinterpretation by the minister. This causes breaks in our legislation which need to be curbed for. As the minister has absolute discretion as to whether or not to grant a warrant, there are contents that are supposed to be in each warrant, and these include the person or customer whose communication is to be intercepted, the telecommunications or service provider to whom the direction to intercept must be advised, the nature and location or facility from which the communication is to take place, and then full particulars of all facts and circumstances alleged by the applicant to support the grant of the warrant. and whether or not there are alternative investigative procedures that have been undertaken to ensure that such information can be obtained and these have been fully exhausted. Now, when a warrant is granted, it will be granted for 3 months and no further. However, warrants are subject to renewal by the minister. Warrants are initially valid for 3 months, but they can be renewed for a further period of 6 months. The Act provides that warrants are valid for a period not exceeding 3 months, but may be renewed for good cause shown by the authorized person, by the minister, in respect of a serious offense by the organized criminal group or for a purpose specialized in Section 6, subsection 1. Now, this clause is subject to misuse as there is no limit to the number of times that a warrant can be renewed, and also there is no clear definition on what good cause really is. Therefore, again, there is a gap in our legislation as to the renewal of warrants. Furthermore, when it comes to the renewal of warrants, the minister may consult with the Prosecutor General under the Constitution provided in the Act. The problem arises from the fact that the Act only speaks to the consultation of the Attorney General, but it is silent on the issue of consent to renewal by the Attorney General. Therefore, the minister only gets to consult the Attorney General when it comes to issues of renewal of a warrant, whereas the Attorney General was never involved during the first initial grant of such warrant, which is also something that is lacking in our Constitution. And then there is a center that has been created by the Constitution, which is to manage onto the centers that have been made to monitor interception in Zimbabwe. Section 4 of the Interception of Communications Act gives birth to the Cybersecurity and Monitoring of Interception of Communications Center, which is an office that is an entity in the President's office that is run by technical experts who are to monitor and control the interception of information and in Zimbabwe. Functions of the Cybersecurity and Monitoring of Interception of Communications Center are outlined in Section 4, subsection A to J, and these include that the monitoring sector shall be the sole facility which will the interception center shall be the only facility through which authorized interception shall be conducted. This means it shall be the only body that has power to allow or disallow warrants of interception. The center shall advise government and implement government policy on cybercrime and cybersecurity, and it will also be the one to identify areas for intervention to prevent cybercrime. It is also to watch out for loopholes that may be used by cyber perpetrators and is to close them promptly. Another function of this center is to create a whistleblower system that enables members of the public to report alleged cybercrimes, and the system should provide witness protection and should be available on call 24/7. Among these are some of the functions of it, and it further gives birth to the Interception of Communications Act also gives birth to another entity called the Cyber Security Committee. This is an ad hoc advisory body to the minister that is established by Section 4B of the Act. The Cyber Security Committee constitutes of 11 members who are appointed from various sectors, and each of these members is a representative of the Postal and Telecommunications and Regulatory Authority of Zimbabwe, the ministry responsible for information and communications technology, the Zimbabwe Republic Police, the National Prosecuting Authority, the Central Intelligence Organization, the Prisons and Correctional Service Center, the Cybersecurity and Monitoring Center, among other sectors. The minister will appoint any one of these representatives to be the chairperson of the Cybersecurity Committee. Then remedies for breach of a warrant of interception. The Act provides for remedies for any breach of the provisions of a warrant. Any person who is aggrieved by a warrant, a directive referred to in Section 6, subsection 2A, or a directive or other issued by the authority, is to report to the administrative court within 1 month of being notified or becoming aware of this breach, as the case may be. Then there is also review of the minister's exercise of power. Under the Act, the only oversight of the warrant regime comes from the Prosecutor General, but there is secrecy surrounding the process. The Prosecutor General receives an annual summary from the minister detailing the particulars of every warrant which during that calendar year was issued by him or her but not renewed. The Attorney General may in turn make written recommendations on how the powers of the minister shall be exercised. The review powers of the Attorney Generals are ineffective as they are given ipso facto. There is no specific provision that speaks to compliance with the Attorney General's recommendation. The minister may decide not to act upon the recommendations given. This is yet another gap in our constitutional legislative system, as the Attorney General only gets to review or after the minister has already taken action in terms of the interception or grant of a warrant of interception, which reverts back to how there is an impartial system when it comes to warrants. And this marks the end of our presentation. Thank you.